Folks,
Absolutely.
yeah, if you've just tuned in, this is the team from Malik&Associates. We have attorney Adam Malik and attorney Joe Pao, and they would be more than happy to answer any questions that you may have with regard to immigration law and family law, Adam, or either or.
Yes, immigration law and family law. I think Joe has a couple of topics that he wants to touch to let our community know about different, issues that may come up in a family law situation, Joe.
Yeah, one of the things that we tend to talk a little bit about almost every time we do this is the procedures that have to be followed to get a divorce or a modification done. A lot of times people don't really have a conception, a good, accurate perception of how long a divorce might take. Typically, it takes a good while, 4 to 6 months, even for a relatively simple case.
But tell me about something, Joe. Some people ask me if there's a waiting time once the divorce is filed, because there is a cooling off period. Isn't there one?
Yeah, there's a statutory 60-day waiting period. A judge can waive that, but generally only if there's been a conviction for abuse. So there's an automatic 60-day waiting period. So 65 or 70 days is as fast as anyone can get it done, and that takes some luck with the courts as well.
And I think that's probably because, some people who ever file for divorce in the moment of anger, and they want to give them a chance, an opportunity to cool down,
right,
and maybe protect a marriage.
Yeah, it's probably a good law, and our firm supports reconciliations, as you're well aware.
Absolutely.
If somebody tries to reconcile, we try to help them.
Okay.
Fanisha, good evening. You're live on air. Please go ahead and ask your question.
So I'm planning to change the job. My wife is on H4, and so my current employer, he's telling that suppose if I change the job, or in case suppose if I resign, they are going to withdraw my H1. So if they withdraw my H1, how that is going to impact my wife's H4? Provided the new company will transfer my H1 and I will have a valid H1. So do I have to, file my or transfer my wife's H4 as well when I change the company? Because my wife's H4 is valid till October 2023. So do I have to transfer my wife's H4 as well?
Thank you. Thanks for that question.
So I want you and our remaining listeners to understand that a derivative status is based on the principal holding their status. So as long as you're on H1 and you have filed the change of employment, your wife remains on H4. Your wife does not have to do anything, because the only reason she has a status is because she's married to you. Now, if there was, not in your particular case, but some people may be affected, if there was a divorce, which Joe here deals with all the time, and one of the spouses is on H4, their status will terminate on the day judge will sign the decree, not while it's pending. And Joe can talk a little bit more about that if Joe wants, but as far as you're concerned, H1, you do the change of employment, and your wife remains exactly the way she is, which is H4. She does not have to do anything. Joe, you want to add anything to that?
Yeah, I was just going to add that not too long ago we had a case where we kind of stretched it out because the person's status was going to change due to a divorce, and we got the divorce delayed.
Until she was able to get her own status, I remember.
Right, and the judge was very helpful within that.
Thank you. Piyush?
All right, thank you for that. Let's take our next caller on air. Fanisha, good evening. Please go ahead and ask your question.
Filed my case on January 26 for neutralization. It is almost more than 3 months, and I'm waiting for the biometric notice, but I haven't got it so far. So what could be the reason if they don't, even if they want to use my old record? So are they going to inform me or not? Thank you.
Did you receive a receipt notice that your application's been received, sir?
Yeah, I got that.
Okay, please listen to the answer off air then. Thank you. So when you file an application with immigration right now because of COVID, and they never really were doing this before COVID, they're using your biometrics, which is basically your fingerprints and pictures from your older application. So whenever you filed another application in the past with immigration, they have a database where they keep all the fingerprints and pictures and biometrics information. So now, because of COVID, they're trying to minimize the waiting time and basically the impact of COVID towards the staff that works for USCIS. So they have been reusing the older biometric information that has been stored with them. And so if they do that, they will let you know, they will send you a letter stating that they're going to use your previous recorded information for the biometrics, and you are not going to have to provide that again. However, this can take many months before you hear something from them. So just because you have not heard or haven't gotten a letter, I don't think there's a reason to worry. That's not a cause to worry as long as you've gotten the application's receipt notice that they have received your application. They've provided you with a receipt number, which is the application number, so you can track it. That's really all that you need to worry about. I hope that helps, and I wish you all the best.
You know, a lot of times one of the things that people need to know is, what starts the process of a divorce.
Right.
And it's called a petition in Texas. Different states call it different things. But someone files a petition for divorce, or if they're not married, they can file a suit affecting the parent-child relationship. People that are not married can still get action in family court.
Now, Joe, a lot of people, from our community wonder, is this something that they can handle on their own? They really don't want to pay people like you to do all this work because they think that, sometimes lawyers are very expensive. So can they handle this on their own?
I've seen sharp people, well-educated people that are able to do that. And I've seen people who work very, very hard that are able to get it done. But it's a complicated process, and if I always tell people, if you can afford an attorney, you're better off with an attorney in a divorce action. However, if a person's very limited on financial situation, it can be done. It's a lot of work.
And I was going to add to that, many years ago, Joe, I had somebody who really wanted an attorney but couldn't really afford one. And he started the process on his own and ended up giving up his job because of the time that he had to spend to research and do all the work. And then, there's small rules that have to be followed. And you have to talk to the opposing counsel. You have to do conferences. You have to serve other parties with the documents. And if you miss any of those small nuances, then you are going to get a decision that's going to be against you.
Correct. And it can be very complicated and overwhelming for somebody that doesn't do it every day.
And that's correct. And so it is a dilemma for a lot of people.
Sure.
Do we hire an attorney, or do we give up our job or our employment and start doing this full time? And you also have to understand you're emotionally charged when you're going through a divorce, and you can't really handle anything like that on your own. Piyush?
Yo, you're live on the air. What is your immigration question, please?
Hi, thanks for taking my call. So my quick question is, currently I'm on H-1B, my 140 is approved, and my wife also is working on her H-4 EAD. My H-1 is due for expiry in October 24. So I'm planning to start the process as soon as possible, basically 180 days before. So my question is, should we apply for my wife's H-4 as well as EAD concurrently? Or, I'm thinking from a timing perspective, right? So we want to get her EAD as soon as possible. Or should we just get my H-1 renewed in premium processing and then go for stamping in India? Thank you.
Thank you, and you can listen to the answer off air. Go ahead, Mr. Malik.
So I think there was a lot of disturbance, but I think I've got what he was asking. This is a personal preference, really, if you want to go for stamping or if you want to do an extension of stay here in the United States. Understand that the work permits don't necessarily get filed or are renewed just because you get stamping done and you enter. I mean, obviously there's extensions that go into play depending on if you're meeting the requirements of automatic extension. But the recommendation is that you file at least 6 months in advance your work permit renewal. You definitely want to also do the same thing for your own extension. And if you do premium processing, then you know for sure that your case has been approved. It's not pending, and there's going to be no RFE that's going to be expected. And therefore, that I think is a better way to handle and minimize the time of being out of an EAD. Now, having said that, it is always advised to talk to the attorney who's handling your case because there may be information that may be affecting your case that we don't know about over the radio, because this is just a quick question-answer session and should not be taken as legal advice. I wish you all the best.
Right now, Furniture Radio, you're live on the air. What is your question, please?
Yeah, hi. My name is Jeet, and I have a question regarding the H-1B extension that is for the 7th year. Wanted to know, my extension just got approved for 2 months, but as per attorney, since the perm is filed a year back, so as per AC-21, it should be, I should be eligible for 1 year, and they did file the same in petition, but somehow it just got approved. Yeah, my question is is there a way we can rectify the end date by working with USCIS?
Please listen to the answer off air. Thank you so much.
Thank you so much for your call.
So look, if the government ever makes an error, yes, you can always communicate that with the government and file a 290B for a motion to reopen and reconsider a case, and that's how you bring that to the government's attention and get an answer, basically a formal answer, and that's the way to do it. File a I-290B, and then you can get the government to respond to that. I wish you all the best with that.
Thank you so much for that, Mr. Malik. Let's go ahead and take our next caller on air. Furniture Radio, you're live on the air. What is your question, please?
Hello. Thanks, Piyush and Mr. Malik, for taking my call. Okay, I had applied for citizenship through employment-based visa, and I got a letter saying that they will use my biometrics that they had, as Mr. Malik mentioned earlier. And I also got an interview call. So my question is, what documents I need to take?
Thank you for the question. You can go ahead and hang up and listen to the answer. Thank you.
Oh, okay. Thank you so much.
Thank you.
All right. So the young lady asked a question that she's filed for citizenship, and she's gotten her biometrics taken care of by them reusing the biometrics that she previously presented. And she's going to an interview now, and she wants to know what kind of documents she needs to take with her. So basically, you need to take your identity documents, for example, driver's license, your passport, your social security card, and your green card. You don't really need to take any specific documents. If there is something that's needed, then the government will specifically ask you for it, and they'll provide you a list. Obviously, there's no way to know what government wants to know and what kind of questions they might ask. So you can't take everything with you. So the best thing is you don't have to take anything with you. That way, if they issue you an RFE and they want specific information, you can come home, you can think about it, you will have time and properly respond to them. Giving something to them in the hot seat haphazardly can a lot of time cause problems, because you may give them the wrong document, or you may provide information that you shouldn't have provided, or other reasons where protections should have been put in place that are not going to be put in place because you quickly presented that information to them. So I would say don't take anything. If they need something, they can issue an RFE, and then you can respond to that. I wish you all the best.
Thank you, Mr. Malik, for that response. And let's take our next caller on air. Furniture Radio, you're live on the air. What is your question for Mr. Malik?
Yes, sir. My question is, my son was here on H1 in 2011, and he went back in 3 months. And after that he has not come on H1 back to USA. So if I have any business who can accept the H1, can we have that renewed, or can he come on that same H1 again to USA?
Mr. Malik, do you have any follow-up questions?
No, I don't. Thank you so much.
If you can please listen to the answer off air. Thank you. Go ahead, Mr. Malik.
Okay, so my quick response to this is that no, he does not need to file another H1. If he had an H1 previously and he only used 3 months of it, he went back, and then if he wants to come back with a new employer, he can do that. Obviously, he's going to get a new visa that might be expired, and he would have to show that he only used 3 months of the H1 time. Now, there may be a statute of limitation that I can't remember right off the bat. So when you talk to an attorney that you hire to do the whole process, they can go back and look at the specific law to make sure that there's not a time frame within which that they have to come back. My memory, if my memory serves me correctly, there isn't, but I would confirm that with an attorney who can do that research for you. I wish you all the best.
Here, Furniture Radio, you're live on the air. What is your question, please?
Hi, I have a quick question. My wife traveled back from India to US and she had a stamp visa till 2025 November, but since her passport was expiring in 6 months, so the CBP officer gave her that much of I-94. So my question is can we go again to some CBP officer in Dallas, and since she got a renewal passport, will they update her I-94? Can we do that?
No, the answer is no. I will give you a more detailed answer off the air. Please just listen to my answer on the radio.
Thank you for your call.
Okay.
So once an I-94 has been issued, and it's correctly issued in this case because the passport was only valid for a shorter period of time, now that your wife has extended or renewed her passport, what she needs to do is make a new entry or file for an extension. So if she still has a visa in her passport, they can step out and come back in, whether to Canada or Mexico if she still has the visa. If she doesn't have the visa, then she can file for an extension, but she would have to go through that process to get an extension for the I-94. I wish you all the best.
Thank you, Mr. Malik, for the answer. Once again, if you have a legal question for Mr. Malik, the number to the studio is 972-235-5555. Furniture Radio, you're live on the air. What is your question, please?
This is with regard to the green card renewal. Actually, me and my family, we are basically, we'll have to renew the green card in next 2-3 months time frame. So the quick couple of questions about that. Obviously, one of my daughters, she is now 14. So my one of my daughters, she's going to be 14 in June of this year. But before that, only we will have to file the application of renewal of green card because the green card is getting expired in the May of this year.
Right.
So in that case, do I have to select one of those options where it is mentioned? If a person is turning, if it is turning 14 before I file the renewal and before she reaches to 16, so that option I need to select for her, right? So that's my question one. While filing out her form, and secondly, the second question is, do we all four of us has to go for the biometric? Or would they take the biometric what we had given to them when we entered, let's say, last year when we had come back from India? So
okay.
That's another question.
Thank you very much for your question. Please listen to the answer off air, sir.
Thank you for your call.
Yes.
So those two are very good questions, sir. The answer to your first question is that you do need to let the government know that your daughter is turning 14, and so the option that you mentioned earlier would work as well. And even if you don't, I mean, they'll realize that the ages are changing, and they will do that. You basically just need to file for a renewal. As far as the biometrics of all family members are concerned, yes. So unless the government issues you a letter stating that they will reuse the previously provided biometrics, all of the family members will be scheduled for new biometrics. That is something completely within the discretion of the government. Nobody has any say to that. That is something that's required by the law. The government can waive it if they want to, if they feel that the biometrics are still good and they can still use them. Otherwise, you will have to appear to provide the biometrics at the Application Support Center. I wish you all the best.
Radio, you're live on the air. What is your question, please?
Hey, this is Gil. My question is, I'm a U.S. citizen. I applied for my parents last year in March 2023. Since August 2023, I didn't hear anything about it. If you can tell me how long is the process?
All right.
Thank you for your question. You can go ahead and listen to the answer off air. Thank you.
So, unfortunately, it's taking a long time to process these applications, which seem to be much quicker back in the day. Even when they were much quicker, meaning about a year for the whole process, people used to come to me and complain that 1 year is too long. Unfortunately, now it's even longer post-COVID. So having said that, there are several government entities that play a part. First is USCIS, then is the NVC, and then finally the U.S. consulate or the embassy. And depending on where your case is, you can certainly go to USCIS's website and look at the normal processing time. Sometimes the cases go beyond normal processing time. So although it is not unusual that the government has not responded or communicated with you, you just have to kind of follow and see if it is within the normal processing time. If it falls outside of the normal processing time, there is something that is known as a writ of mandamus that we do for our clients. We file a lawsuit against the government to do their job, and then they very quickly respond when they are outside of the normal processing time. If that's the case for you, certainly make an appointment with my office and come and see me. We'll be happy to help you. Now, coming to the NVC portion or the interview process, that is taking sometimes around 3 years after USCIS approves your application and you are documentarily ready. So it all kind of depends on how busy the consulate is or the embassy is where the case will be interviewed. And that is on a case-by-case basis and also a post-by-post basis depending on which post you're using. I wish you all the best.
Thank you, Mr. Malik. And you can definitely call the office at 214-881-2100. What is your question, please?
Thank you for taking my call. So my father, he's on a green card. Can you sponsor my brother who's like 35 years while he's on a green card?
Is your brother married or unmarried, sir?
Unmarried.
Okay. Thank you very much. Please listen to the answer off air.
Thanks.
So a person who is a green card holder, who is a legal permanent resident, can apply for their children that are unmarried. Whether they're under 21 or over 21 is what makes a difference in how long it will take for them to get a green card. But nonetheless, they can apply for their children as long as they're unmarried. However, while the process is ongoing and the child gets married, that petition dies instantaneously unless your parent who filed a green card becomes a U.S. citizen first before the child gets married. Having said that, because your brother is 35 years of age and unmarried, your LPR permanent resident father can file a petition for him. It will just take longer. I think right now, without looking at the exact timing, it's taking about 5 to 6 years for that time, but he can certainly file for him. I wish you all the best.
Thank you for that answer, Mr. Malik. And I want to thank you for providing such wonderful answers to our community here and doing such great community service for our listeners here. Anything that you would like to add and what's happening in the immigration world while we sign off?
Well, thank you very much for the kind words, Webab. And the biggest thing is to watch what's going on. It is the election year. Watch what is going on around the country through all parties, whichever party you support. I ask that you do, if you're a U.S. citizen, you do go out and vote. Register to vote now and cast your votes. If you're not a U.S. citizen, please make sure you do not even register, because if you register, you will never be able to get any benefits through immigration or apply apply for U.S. citizenship. It is what we call a kiss of death of anybody who's not a U.S. citizen who registers to vote or votes. So with that, thank you very much.